Hi, Facebook. I'm Mallory Sofastaii with WMAR 2 News. Thank you for joining our discussion on workers' rights. We are joined by Richard Neuworth, an employment attorney for nearly 40 years. He's here to answer your questions. So if you have any, be sure to write them in the comments section and we'll see them and we'll ask them to Richard. And Richard, thank you for joining us.
Thank you. Good afternoon, everybody.
Richard, can you just tell me some of the issues that you've been hearing from your clients, their concerns?
Yes, thank you, Mallory. Since the COVID-19 pandemic first arose in February of this year, many of the issues are whether or not I can work and what happens if I can't go back to work and how can I get paid and what about my health insurance and what about my retirement plans and items like that are some of the issues that have come up frequently. Other issues are whether or not I can collect unemployment and what happens assuming that I cannot go back to work, can I still draw unemployment benefits? So those are some of the issues. Those aren't all the issues, but particularly in the disability realm, you know, what kinds of accommodations are necessary to go back to work under these circumstances. And since we're in stage 2 at this point of the Maryland reopening, the question is there are several areas that are still not open yet at this point.
Yeah, I've started receiving emails from people as businesses start to reopen. What are employers required to do to keep employees safe?
That's an important question. Obviously, depending on what the type of workplace setting is, whether it's a factory line or some place indoors that requires certain ventilation, they have to ventilate the workplace. They also have to provide accommodations to employees that have disabilities that they know about. And obviously you have to inform your employer about the fact that you do have disabilities and do need some form of accommodations. If you don't, then they have no way of accommodating you. Some of the other issues involve other normal things like what happens because I have to take care of my kids, school is out, the kids are sick, or close family relative. Many of those employees will be eligible either for paid leave, paid sick leave, or for just paid leave or other kinds of leave as well that's unpaid.
And I just want to address Dee Thompson's comment, why am I still looking for my unemployment since March? We have been hearing that a lot of people still waiting on their unemployment insurance benefits. You just have to keep trying to call and email, reach out to your local delegate and state senator. I just wanted to make sure to address that because we are answering your questions live. So if you have a question for Richard about returning to work, any concerns you have, feel free to ask that in the comment section.
Another thing you might want to do is contact your county executive or the mayor if you live in Baltimore City and see what they can do to help as well.
Absolutely. And last we heard, they are trying to triage some of the complaints that came in March and early April. So definitely just keep trying to reach out as best you can to see what's causing the holdup there. Where can employees turn if they do have concerns about their safety or, they don't see protective measures in place?
There are several government agencies, one of which is the Maryland Occupational Safety and Health Administration. There is a Federal Occupational Health and Safety Administration. They can also contact the National Labor Relations Board. Those are the principal agencies. If they want to file discrimination complaints, they can either file them with the Maryland Civil Rights Commission, which is located in Baltimore City, or the Equal Employment Opportunity Commission, which is also located in Baltimore City. My recommendation is to contact those agencies. There are also some county and city agencies that the remedies aren't as extensive as they are with those two agencies. So those are some of the agencies that one can contact, assuming that those are issues come up. The one point I do want to stress is the fact that if you do need accommodations, you must make your employer aware of the specific type of accommodations. And also, if it's a health-related issue, you should certainly get something from your treating healthcare provider to indicate what specifically that you need. And also, if you can furnish it yourself and there would be no cost, obviously, that would be something you would hope that the employer would agree to. If the employer has to pay for it, depending on what the cost is, or to talk to your co-employees to see if schedules could be altered. So those are some of the things. Also, to find out if you're qualified for other vacant positions that you could telework from. Those are also some ideas as well.
And I think I would recommend, or you might as well, that people should reach out to their doctors as soon as they can if they do require a note versus waiting for everything to reopen.
Right, and indicate, what kinds of accommodations in order for you to be able to work. Either work in your normal work setting or work from home under either scenario. So those are the kinds of things I think that should be done in order to do it. But again, you can't keep this a secret. You have to let your employer know that.
We have a question from John Kennedy. He says, I have contacted the county executive. My old employer told unemployment I was on the payroll, which is not true. It has stopped unemployment, and unemployment is accusing me of fraud. What can I do?
Under those circumstances, what I would suggest he do is contact a lawyer, or principally, if he wanted to, the Lawyer Referral and Information Service at 410-539-3112 in Baltimore City. There are also some lawyer referral services in the various counties. There may be legal issues as well, like, for example, the previous question as well as this question concerning your employer, and you should contact a lawyer, either us or someone else. But again, those type of issues you should definitely seek legal advice about.
And, people are on unemployment. Money's tight. There are ways of getting legal advice without shelling out a lot of money, correct?
Correct. I mean, most attorneys aren't going to charge for for a consultation over the phone, depending on what type of services are necessary. The unemployment has a low income provisions in there. Attorneys can't charge that much as well. So that also is something. And there are attorneys that just handle unemployment issues.
What if employers reduce someone's pay so they're making less than they would on unemployment?
That's a difficult question. The unemployment benefits under some of the new federal laws have increased so that some employees actually will be making less than what you could get on unemployment. Is that lawful? The answer is probably yes. One obviously can't say under all circumstances. However, this is something, again, you should consult with an attorney about, either us or other private law firms, concerning under what circumstances the pay was reduced. If it was reduced for a discriminatory reason, then it wouldn't necessarily be lawful. And if it was reduced for other reasons that are unrelated to the pandemic or economic conditions, that also is something that can be. But in the abstract, unfortunately, there are certain people that have to make a decision whether to collect unemployment or to work. Obviously, I think most employers would like them to work, understanding at some point, though, in the future, hopefully they would make up the difference. At least I would hope so.
Jamie Steele has a question. If you were being treated as if you had COVID-19 before tests were readily available and said you had it, and then were tested and tested negative, is it okay for an employer to terminate you? The VP stated she was told I tested positive and negative, but let's go with the first part of the question.
Sure. I think the answer to that is probably not. And the reason for that is, and this is somewhat of a complicated answer. The question is whether or not COVID-19 is, in most disability discrimination cases, the issue of whether or not one has a permanent condition or belief that one has a permanent condition, you cannot terminate someone based on that belief, particularly if it's an erroneous belief. The question really is COVID-19 a permanent medical condition? The answer to that, unfortunately, isn't so obvious. Obviously, there are certain circumstances it could be where particularly it aggravates existing conditions that are permanent. So the answer is I would need to get more facts, but I would certainly think this is something that the individual should contact a lawyer, either us, because our firm handles a lot of disability cases, or some other private law firm. And certainly should apply for unemployment, and unemployment will also list the reasons why someone was terminated from employment, which would be useful as well to educate the attorney about too.
Yeah, it says she's waiting for an interview. She's been waiting since mid-April. So I have a feeling that question will probably come up.
Right.
Would this fall under good cause, you think?
No, I don't believe so. Based on the facts as presented, no, that would not appear to be good cause. And certainly our understanding of COVID and treatments related to that would not take, depending on the severity of the medical condition, it would not be, unless the person is actually hospitalized and on a ventilator, usually the treatments don't last that long and the overwhelming number of people recover. So under those circumstances, without knowing all the facts, more facts, I would say probably not. But certainly the individual should apply for unemployment.
Absolutely. And I just want to backtrack to when I said good cause versus valid circumstances. Right. So basically when you apply for unemployment, they have to look at why you were terminated or let go, or if you quit, and they kind of go through those different situations.
Right. I'm obviously, in this particular case, merely firing someone because they have a positive COVID-19 test is not a valid reason on its face. We don't know all the facts. Depending on the size of the employer, whether they needed someone to work immediately and the person was unavailable for a certain period of time. But certainly this would not be a disqualifying reason for unemployment benefits. And the individual should, get a determination from unemployment, which they will give them, because they do give out determinations in all cases except an economic layoff. And that's certainly someone who should contact a private lawyer.
For people who do have concerns, they might have some kind of health condition and they're not comfortable returning back to work.
Yes.
Will it depend on what kind of health condition they have? Is unemployment going to make that decision for them, whether or not they will still continue to get benefits?
Yes, based on the nature of the condition, whether it's COVID-19 or whether it's some other medical condition, it's difficult to say in the abstract unless you know the specific medical condition and what types of accommodations that the person needs. There are several types of chronic medical conditions that make them a higher risk for working in certain types of work settings. So there are two issues that an employee should think about. One, if there's another vacant position you're qualified for, you should certainly apply for that position, particularly if it would not jeopardize your health in the same way the existing position would. Or another possible alternative is telework under these circumstances, or to change your work schedule in such a way that the risk is reduced so that you're not in contact with as many members of the public. So those are some of the ways that you should think about dealing with those type of medical conditions. At least that's what I would recommend.
And the same goes for, maybe someone who's healthy, but they live with someone who has a health condition, and say they're a server, or, they interact with strangers daily. That could also be a reason to maybe not return to work, but they could still potentially qualify for unemployment.
That's right. Under those circumstances, particularly, and they also may be entitled to paid leave as well. So that's something else that they should think about. They could get 2 weeks potentially of paid leave, depending on what the nature of their employment is, and then they could qualify for the enhanced unemployment. I have a situation now where I had someone else who had to take care of his wife who was sick. He had to work outside and was exposed to the public. He just couldn't continue to work under those circumstances. I mean, that would make him eligible both under the Family and Medical Leave Act and other types of programs as well.
You mentioned that, he's a client of yours. Did he have to pursue an attorney because he was getting pushback from unemployment? Is this going to...
No, it wasn't from unemployment. It was from his employer. And the question was whether or not, either he was anxious to retire. So the question was, well, I explained to the employer and their counsel that, he wanted to get out of his existing employment agreement because he needed to take care of a sick relative, and he could not be exposed to the public because of the nature of her illness, which was not COVID, but certainly if he contracted COVID, he could not take care of her under those circumstances. So they understood that, and they were willing to work with him on that so that he could do what he needed to do, which was retire. And actually, it was a win-win for both because, frankly, they didn't have to take care of the Family and Medical Leave Act obligation and the health insurance obligations associated with that, or unemployment, by just allowing him to retire.
And just a reminder for anyone watching, if you have questions for Richard, he is here to answer them. Just write your question in the comments section and we will get to them. Pam Batty had a question. When is Beacon going to correct our answers from the old system? The Department of Labor says that they've done this already. So if for some reason you're not receiving benefits, then you need to call the claims center to figure out what exactly is causing the holdup. And unfortunately, we know that it's still really difficult to get through by phone or email. A question I really want to know, are employers required to disclose whether or not someone tests positive for COVID-19 in the workplace?
I think the answer to that is only essential personnel that have a need to know are the only ones that should be permitted to have that information. Otherwise, I don't think anyone else is entitled to that information. So that would be how I would answer that. And then that's the same with any other type of illness. It's certainly a need to know situation. There are risks, of course, involved if someone else is exposed who isn't aware of it, and or someone who takes the illness like COVID home with them. I mean, there is a lawsuit now against Amazon over that, because some of their workers on the factory line went home and exposed certain relatives that lived with them to the illness. And they were not informed necessarily about who did and who didn't have the disease. But generally speaking, under most federal laws and state laws, it's people that have a need to know are the ones that should receive that information. The employer has to make the judgment as far as what that is, which individuals those are, whether it's just management or whether it's everyone. Generally speaking, I think most would not like to have someone working there who's been exposed to COVID-19. And, the incubation period is, I think, like 14 days from the time a person, and that is a relatively short period of time. So after that, then there shouldn't be a problem.
Is there any time requirement for notifying employees? If, they get a call from an employee saying they tested positive and they sit on that information, is that? illegal?
Well, I mean, the question is whether or not, again, it's a need to know situation, whether the other employees need to know. If I were representing an employer, which I don't, I just represent employees, I would certainly consult with a healthcare provider, an infectious disease specialist, as far as who needs to know and whether or not the other employees need to know. I mean, if someone tests positive but doesn't develop symptoms of the illness and for 14 days, I don't think anyone else is likely to contract the illness. So I think that is an approach I would use, but certainly consulting with an infectious disease specialist for the employer and certainly that individual could advise them as to who has a need to know, whether everybody does or whether only a few the people in management need to know.
Okay, Lisa Massey has a question. I was furloughed until July, but just received an email from an HR exec that it has been extended until October. Do I have to submit a new claim or stay on unemployment insurance? If so, what? Thanks.
Thank you for the question. I think you don't have to do anything. I think you can continue to stay on unemployment for up to 6 months. The one thing at this point, and this is somewhat up in the air, is the enhanced unemployment benefits are supposed to expire in July. Congress has not yet renewed it. So I can't tell you with specificity whether or not you're still going to you will get unemployment benefits. But I can't promise you that you're going to get the enhanced unemployment benefits. The enhanced unemployment benefits are only for 4 months. 4 of the 6 months. But that, again, is subject to an extension from Congress, which may happen and should happen in July because those benefits are scheduled to expire in July.
So she should just continue filing those weekly.
Yeah, she should continue to file. But like I said, unfortunately, you can't promise you're going to continue to get the enhanced benefits. You will get the normal, regular benefit.
Mm-hmm. Deborah Denhart has a question. Is there any time you need to appeal the decision to unemployment because you'll be able to verify that you are not employed now?
The answer to that is no, unless you're fired for gross misconduct. And if you are fired for gross misconduct, you certainly should appeal it. Or if you get a penalty for misconduct, and those penalties for misconduct can last up to 10 weeks. So the answer is, under those specific circumstances, I would think about appealing. Otherwise, if you are found to be ineligible for whatever reason, depending on what the nature of your employment is, that may be another circumstance when you might want to do it. For example, there are certain self-employed individuals that became eligible for unemployment benefits. However, that only kicked in after a certain period of time. So generally speaking, that would be a difficult thing to appeal. However, that may also be an issue for whatever reason. And the other thing I wanted to mention, Mallory, is that the fact that you have another job does not necessarily mean you won't be eligible for some type of unemployment benefits.
And if your hours were reduced too, under the CARES Act, you could
Right.
be eligible.
Yeah, you could also be eligible. So, you know, if you have like a part-time job that pays a couple hundred that may not exclude you, and you should certainly continue to file for continuing unemployment benefits.
Jamie Steele had a follow-up question. So if you are a teleworker with zero contact with others, can an employer ask you for test results if you are sick?
I don't know under what circumstances they would ask you to do that unless you have to come into the office for some reason. If you aren't coming into the office and you're teleworking, I don't know why they would want to test you. I mean, I would try to find out from the employer what specific reason they want you to come in. And if you're not coming into the office, I don't know under what circumstances they would need to have a COVID-19 test.
Yeah, and I think it is challenging for some people because, the governor has said while offices may be reopening, you should still telework if possible. But for, people in the restaurant industry, that's not an option.
No, it certainly isn't an option. But, both at the federal and state level, and the governor has made that clear in terms of the reopening. Governor Hogan has certainly encouraged people to telework, but that's not just here in Maryland, it's everywhere. But you're right. I mean, there are certain occupations there simply cannot be teleworking. The only thing is sometimes with restaurants, and this really isn't either a workable solution, you could exchange shifts to go on a shift where there are less contact with people in the general public, but you can't make it so there's no contact. I mean, that's just not going to work. The other problem is like factory assembly lines, things like that, where there are ventilation issues. It's very difficult to allow people not to work in an environment where they're going to be subjected to, close contact with other workers, even though some of the factories have been redesigned so that to permit more like shields and other things but I mean, it's a problem.
I think we saw that with some of the meat producing plants,
That's
how
right.
quickly it spread, and people had no idea
Right.
what was going on.
Right. And it's just very difficult to stop. And particularly, this is an airborne disease that, if somebody sneezes or somebody gets eyes start watering, I mean, the droplets easily can go 6 feet, without too much happening, or coughing. I mean, even with a mask on. Obviously, a mask would help, but it's not a solution to all problems.
Speaking of masks, are employers required to provide a certain number of masks? Are they required to provide cleaning supplies? And, are there standards for cleaning that they'll be held to?
That's an excellent question. The Wall Street Journal, by the way, had an article this week on that issue. Well, first the question is, what type of mask? I mean, is it an N95 mask? Is it which is generally the standard that's industry-wide standard that's the best in the field. The second issue is there's certain masks that Battelle National Laboratories, which is a nonprofit, has sent out, and there are questions about whether or not the cleaning material, they essentially said you could reuse these masks up to 20 times. Unfortunately, there are certain chemical agents that they use to clean them, and there have been problems associated with those particular masks. Certainly, you could look online to see what type of mask they're asking you to wear, what type of cleaning materials, whether you're allergic to those cleaning materials, and things like that. There is nothing that precludes you from getting a mask that you consider to be safer as long as you tell your employer about it. And if you're willing to pay for extra money to get something that you feel will give you a higher level of safety and comfort, I don't see why your employer would object to that. And but this is, you've read stories. I mean, this is like the Wild West with regard to masks and other type of personal protective equipment, because there's a lot that's been sold and we're really not sure about how good it is and whether it's workable or not. And the other thing you might want to check on is the Food and Drug Administration in Rockville, their website, to see what kinds they would recommend as well.
And as far as cleaning equipment solutions, how frequently they have to, wipe down areas? Are they controlled by the CDC guidelines, or, are they held to a certain standard?
Well, I would argue they should follow the CDC guidelines, because that would certainly give the employer a certain level of protection so that they wouldn't have to, be sued under those circumstances, either for an employee filing a workers' compensation claim or other kinds of disability discrimination. So yes, that would be something I think would be a wise decision on their part as well.
When we spoke a few days ago, you mentioned that it was important to discuss health insurance with COBRA. Can you talk about that a little bit?
Sure. COBRA, there are two types of health insurance that private employers offer. First, for those that have more than 20 employees, which is covered by the federal COBRA statute. Those that have less than 20 have what are called the mini statute. Employers have to provide notice of, in the event someone is laid off and their hours are reduced to zero, has to provide them with a COBRA notice within 44 days. If, in order to comply with the Federal CARES Act and other statutes like that, the employer still may be responsible for paying for the health insurance of employees. But assuming that this is going to be a permanent layoff, they have to give them the COBRA notice. Or if they're not going to pay the health insurance for the employee, or if they're responsible for some of it, they, in my view, have to issue the COBRA notice. If they fail to offer the COBRA notice within that time period, they can be subjected to both tax penalties as well as a monetary penalty of $100 a day. Employees can purchase coverage at a later date and time if they were laid off during the course of the pandemic. Normally, if you don't pay the COBRA premium within 63 days, you have a break, and you have, in terms of pre-existing medical conditions. However, as long as the pandemic is in effect, you can purchase the insurance not 30 days after the notice is issued, but as long as the pandemic is goes on for. So this is an important development that permits people to purchase health insurance beyond the normal 30-day period. One of the things that was puzzling to me is if you go to a healthcare provider, you're hospitalized, your healthcare provider could also pay for the COBRA premiums as well, assuming they want to get their medical bills paid. And to be hospitalized in an emergency room or as an inpatient could run hundreds of thousands of dollars. So certainly that's something to discuss with a hospital, or certainly, like I say, you can pay that after the normal premium dates that are due, as long as it's as long as it occurred during the COVID period. So the normal periods have been waived. And some of the other things with regard to health insurance, if it's denied and you have to appeal, there's a claims process. The normal time periods are also waived, so you have more time to appeal those decisions as well.
All right. And if you have any questions for Richard, again, just put them in the comment section and we'll be sure to bring that up. John Kennedy, he says, thanks for your help. I'll reach out to you on Monday. And I want to go back to an email I received this morning. And
Yeah.
we touched on this earlier,
Yes.
but I think it's important to go back to it. So she says, I'm a massage therapist. In my profession, you can't social distance. I work in a day spa. Although the owner has taken a lot of precautions, we still cannot social distance to ensure our safety as therapists. If I refuse to work, it's possible that I will lose benefits from unemployment that I just received 3 days ago. But I cannot afford to stay home with zero money. I'm eager to get back to work, but only when it's completely safe for me to do so. She didn't mention, any concerns about health conditions. So what are her options?
That's a difficult situation that she's in. I think if there are health conditions, obviously, as we said before, you should speak to your doctor as far as what's necessary to be able to do the work. If you have no specific health conditions and it's a fear of becoming infected, I'm not sure that by itself is going to prevent an employer from terminating and possibly causing them to lose unemployment. One of the things that might work is to see if they could do this at a time when they don't have to see as many clients, or to see whether or not they could switch shifts with other employees so that the number of people they're in contact with is reduced. The other thing to look into is what kind of personal protective equipment that you need in order to try to safely do the job, and what type of personal protective equipment the employer is willing to offer to you. Those are some of the things that I would suggest. This is a really difficult problem. There is no simple answer to this issue without, a specific permanent medical condition. The other option is if there are vacant positions available at that place that the individual is able to perform other than as a massage therapist, to apply for those positions. That may be something else to think about. If they're a secretarial position or something else that does not require the same type of personal contact with other members of the public.
So it seems like the first step for people who, have a lot of anxiety or are fearful that they could become infected through their line of work is to first talk to your employer, probably express your concerns. But if they're not willing to work with you, then, I guess what you could hire legal counsel or make your case to unemployment.
Well, that's right. Or if you felt you're being discriminated against because of the nature of you have some kind of disability that's anxiety related as well, and particularly those that have expressed those type of have advised their employer about those type of conditions, and that this would cause them to make their anxiety unworkable, then yeah, I think that's something that needs to be explored as well, if that is an issue that the employer is aware of.
Christina has a question. I just had my interview a few days ago. My job said I was part-time instead of on leave of absence. I sent them the paperwork, but still don't see any change in Beacon.
Under those circumstances, if they gave up a position in light of promises of part-time employment, they may want to see a lawyer about that. I'm not sure what because that may be a claim for negligent misrepresentation or some type of misrepresentation claim. With respect to why that isn't the case, I'm not sure. I mean, you don't want to start off with a new employer complaining to the Maryland Department of Labor Licensing and Regulation that you aren't getting paid even though you're available for work or to unemployment. But that may be something that she would like to consider at some point if this continues indefinitely. So that would be something I would suggest.
She just responded. She said, I didn't give up the position. I'm on leave due to COVID.
And the situation, as I understand it, is she now is able to work part-time, but they won't let her work part-time. Is that what she's saying? Because I'm not exactly certain of what she's saying. I mean,
my understanding is that the employer told unemployment that she was part-time instead of being on a leave of absence due to COVID.
Okay. I would talk to unemployment about that and discuss with them what were the specific terms and conditions of employment. Are they in writing? Employee handbooks, things like that. All that should be presented to unemployment in order to determine what exactly is going on here. I don't know whether they're trying to, beat her out of some unemployment or what the situation is, but certainly those are the things. If she is on a leave of absence, if it's in writing and when it was given to her and whether there were any anything either by email or in writing that says otherwise prior to the time she applied for unemployment.
Okay, and just one more final reminder, if you have questions for Richard, make sure to put them in the comments section. We'll probably be wrapping this up in the next few minutes or so. Richard, something else I've been seeing is some employees say that they're being laid off and in order to hire new people, but their employer received PPP money. Is that lawful? Are they required to retain the same employees, or could they hire new ones but still hit that threshold in order to get loan forgiveness?
That's an important question. There are issues under the False Claims Act and other issues concerning that. I think the answer to that is no, they cannot hire replacements in order to keep the PPP money. Obviously, there are certain issues associated with the PPP program that have been revised recently by Congress in the last week or two. I don't think any of those revisions would change the existing law. I mean, the purpose of this was to keep people employed during at least an 8-week period of time. And keeping people employed is keeping existing employees employed, not hiring new employees under those circumstances, because as we understand the law, you have to look at either 2019 or the period in 2020, and you have to get existing payrolls that reflect who your employees were during that period of time in order to get the loan. And in order to carry that out, and there have been some cases that have arisen because of that, where employers have been arrested on criminal charges, but there are also civil remedies as well as criminal penalties.
Thank you, Richard. Is there anything else you wanted to touch on before we wrap this up?
No, this is a very traumatic and difficult time for many employees. And unfortunately, there really are, to many of these issues, there are really no simple answers, except that, hopefully we'll have a vaccine soon, and hopefully we'll be able to get back to some semblance of normal. If they have legal questions, our law firm handles a variety of all types of legal and employment issues, and we'd be happy to talk to them. And I'm sure others who represent employees would say the same thing. And generally speaking, most consultations are over the phone are free. And I just hope, like I say, that most people can get back to work and hopefully be well and stay well.
Absolutely. And if you are interested in reading more about the different guidelines that are out there, the governor's office has put them on their website as far as ways to safely reopen. CDC has put out some guidelines. There is a website by the American Industrial Hygiene Association called backtoworksafely.org. So then you can kind of understand, what is recommended and what your employer is offering. All right. Well, thank you, Richard, for joining us. Appreciate it.
Thank you. And you have a nice day, and be well and stay well.
Same to you. Thanks again.
Take care. All right. Bye.
Bye.